Hello, everyone, and welcome to another episode of Conscious Caregiving with L&L, where we're tackling the tough conversations. The topic this month is legalities and seniors. Welcome back to another episode of Conscious Caregiving with L&L. I am Lance A. Slatton, co-host of Conscious Caregiving, also a host of All Home Care Matters, and the author of the new book, The All Home Care Matters Official Family Caregivers Guide. I have the distinct privilege of welcoming our panel today. First, I'd like to start with Mary Farquhar. She is the CEO of Roger Fisher's Care. Welcome, Mary.
Thank you, Lance. My name Mary Farquhar. I also call myself, for the purposes of this discussion, the Chief Financial Officer of my husband, Roger Fisher. So
there you go.
CEO and CFO, reluctantly CFO.
Well, thank you so much for being here with us today, Mary. Next, I would like to go to elder law attorney, Mr. Ramsey Bahrawy.
Thank you. My name is Ramsey Bahrawy of the Bahrawy Law Office, where we build your trust. I joined the Massachusetts Bar in 1979. I've maintained a private practice in downtown North Andover, Massachusetts since February of 1981. My office concentrates on elder law. Elder law includes estate planning, which means writing wills, a variety of trusts, powers of attorney, advanced medical directives, and where appropriate, declarations of homestead on real estate. We also deal in real estate matters, probate of estates, adult guardianships, advising clients on public benefits such as Medicaid, Medicare, and Social Security, and also selected plaintiff personal injury litigation. As you know, elders oftentimes have pre-existing conditions, and many lawyers are not willing to take those cases. We are, because we feel that compensation is due to people who have a worsening of pre-existing condition. That's what I do.
Well, thank you so much, Ramsey, and those are all very needed services, especially for our seniors. Thank you for being here today. Next, I'd like to go to Deborah Snyder, who is a care partner.
Well, I am Deborah Snyder, but I am as well as a care partner to my husband with BVFTD. I do work with people who have disabilities and are over 60s through our Aging and Disability Resource Center here in Delta Junction. And we're a hub that just connects people with resources, and there's a lot of surprises along the way. And Ramsey covered a lot of the things that I talk to people about, depending on how big their estate is. I don't get into the legal, but I do help with resources, etc. And thank you. I'm very humbled to be here.
Thank you, Deborah. We appreciate it. Next, I'll go to my esteemed co-host, Miss Lori LeBay, who's the co-founder of Dementia Map and the founder of Alzheimer Speaks. Welcome back, Lori.
Well, thanks. I always have fun doing these shows, learn something every single time. And so I'm just thrilled for everyone to be here. I also have been a caregiver, care partner, care companion, whatever you choose to call them, for my mom, who had dementia for 30 years, my dad, who lived with cancer, and then many others throughout my life. So this topic of seniors is really important to me, and I'm looking forward to diving deeper into the legalities and how do people protect their seniors and themselves as a family.
Absolutely. Absolutely. Well, I just want to thank you all for being here today and for taking part in this all too important topic. And Lori, let's have you start it off.
Well, Mary, I'm going to pick on you first and pull you in. So, stepping into the whole legality thing is difficult. I mean, getting the diagnosis is hard. And then all of a sudden, I would imagine it kind of hits you like a baseball in the face going, oh my gosh, now we have to deal with all of this stuff. It's something that we talk about as we age, but not everybody steps into it and embraces it. So what were your feelings about pulling in an attorney? Did you and Roger kind of have your affairs in order already? And
No. Well, thank you, Lori. My husband has Alzheimer's, and I think of all the diseases, all the terminal fatal diseases you can have, it's like if you go to a doctor and you say, how long do I have? And the doctor replies 8 to 11 years. And that just changes the ballpark right then and there. So out of everything I have had to deal with as a caregiver, the most stressful has been the financial planning. And with the cost of care, private care, as it is now, I would urge everyone, you need an elder care attorney. Right now, the full market rate of long-term care is $13,472 a month. You know, in your description about protecting assets, you know, I would prefer to call it stretching assets. What I wanted to do for myself and my husband is I wanted to know how to stretch the money we both had through his lifetime and through mine, if possible. For the average American, you don't have enough money for this disease. I'll just be frank about that. And so where the legalities come in is having to do with more at the most stressful points, more towards the end of life. Are you gonna need medical assistance? Are you gonna need an elder care waiver? And I'll just say to your audience, if you don't know what those terms are, go out, Google them, study them. And then one thing I will say in my experience is that the field of elder care attorney, it's rather a niche, but my experience has been they're usually the type of attorney they get into this business because they've had a family member or they have an interest in helping people. And most, not all, will do a half-hour free consultation where you can, and I suggest you study up what you most want to know to make valuable time of your consultation time. But at the end of it, you should have a feeling that this person gets you, you trust them, and I can only stress it is worth the money. Because what I find, and I'm in 3 caregiver support groups, one of which being Lori's, is that I will say particularly for women in their 70s and their 80s, their husbands did the financial planning. They don't always even know what they have and what they don't have. And they become so afraid and paralyzed that they just keep isolating more and doing more. And where I try to suggest to people is know the disease progression, know your finances. And the way that I describe it, and trust me, I am the most physically unadventurous person in the entire world. I do not want to rock climb. I do not want to scuba dive. You know, I like walking, you know, but it's like this, what I've had to do, I equate it with like jumping out of an airplane, which I have no desire to do. But if I did, I would want to know if my parachute works. I want to know what my backup parachute is. I want to kind of see where I'm landing, and hopefully I will land on my feet. And so when I first started, the Alzheimer's Association would have a consultant at the Center for Memory and Aging. And the first thing they said to me was, Mary, get an elder care attorney. You need a power of attorney. You need wills. You need healthcare directives. And, you know, at the time I was kind of like, oh, don't I need a doctor? It's like, whoa. But, you know, they were right. And I started, and I'm glad I started early. I started when he had MCI. And as scared as I was, and trust me, I was scared, I went to as many workshops that I could. And this was before COVID. There were more workshops, in-person workshops available. I always benefited because in person, I could listen to other people's questions and say, you know, I hadn't thought of that. You know, online classes and resources are great. It's a great place to start. But I always encourage, if you see an in-person workshop on, you know, anything, asset protection or long-term care, take it. The interesting thing about Alzheimer's, and again, because long-term care is so expensive, that it's daunting, but you will be spending your assets towards care. And then it's a matter of how smart and how long and how many family members that you may have to help with your situation. But the issue is if you get, well, I'll say when at this point in life, when you get to that point of applying for medical assistance, you have this 5-year look back period. And so what that means is you can't give away assets to your children or your grandchildren legally, because again, and it breaks my heart when people just think, well, you know, Medicare will take care of me. It doesn't. It just doesn't. But the government will step in after you spend down, and it can be to $6,000 to $3,000. You know, Ramsey knows more about the specifics than I do. But the point is that it's a matter of timing. And when I started this journey in 2018, the other word was, Mary, get on waiting lists for, you know, memory care, assisted living, because there are 2-year waiting lists. Well, you know, I hate to say this, but right now in our area, there aren't many waiting lists because it's so expensive. People are keeping their loved ones home as long as they possibly can. And that's not necessarily healthy for the caregiver or the person involved, but it's the reality of what we're living through. And so I'm glad I started early. I did start early. I still attend every workshop I can on this subject. So I hired an elder care attorney. My husband is a veteran. He specializes in veterans issues. I'm thankful and grateful for having the VA as kind of like my backup. But I just want to say that some elder care attorneys will help you apply for medical assistance. You know, I just think they're so valuable that they're not a luxury. I really believe they're a necessity. So with that, the only other thing I'll just throw out there that I've learned recently, and the other thing, why you need an attorney, is, okay, there's federal bureaucracy, estate law, you know, all the details, but there's also state law. And so part of the reason everything seems so opaque is that your situation can really vary state to state in terms of your assets and what you can and cannot do legally. But in Minnesota, there's something that I hadn't heard before, but heard about, and one was called Medicaid Asset Protection Trust and Medicaid Compliant Annuity. And I'm not going to do a good job explaining this to people, but what I want people to know is look them up, see if they're available in your state. When you interview, and I suggest you interview elder care attorneys, ask them if they're familiar with these. And again, I think except for the 1 or 5% who have a great deal of money, most of us are worried about running out of money if we have someone that we're caring for with Alzheimer's. And to me, getting a good elder care attorney and a good financial planner. I have both. And I did a series of things. So I have kind of, if you will, streams of money. So we'll go through his IRA first, and then he has a Roth IRA. That is separate from my IRA, my Roth IRA. But I have kind of an internal, okay, I'm going to get to here, then I'm going to have to reset, reevaluate. As I continue to monitor where he is physically, where we are financially, hopefully, again, if anything, this disease has strengthened my faith. I know we will be just fine. I just know that. But I just urge people that if you are a caregiver and you're 24/7 on the caregiving, if you have a son, daughter, nephew that you trust, ask them to help you figure out. Maybe they do the screening. Maybe they help ask these questions so it's not so overwhelming. But that's kind of I think I highlighted what I prepared to say, and I hope it's valuable and useful.
Well, thank you, Mary. One question I had was, how did you find your attorney? Did you have one? I mean, because that can be daunting too. How do you pick one? And I loved when you said interview people, because just because someone has a title doesn't mean they're going to do a good job for you. I mean, you have to have a personality match, I think, to reduce the stress levels and things. And so I don't care if it's a real estate agent, an attorney, a doctor, or whatever. I think it's important to check out your options and know that you can freely communicate in a manner that works for you, because not everybody communicates in the same fashion. And that, to me, is just going to add more pressure. So how did you find your elder law attorney?
Well, actually, he did a presentation. I took a workshop called Shaping Your Future through Family Means, a social service agency, and he spoke on legal issues. And he was also referred to me because he specialized in issues regarding the VA. And that was always kind of like, another layer to options that I needed to understand, but he had expertise in. He also spoke at another workshop I went to. But I was so fortunate that I started this before COVID, because before COVID, the Alzheimer's Association in Minnesota, North Dakota did an annual conference, and a bunch of elder care attorneys would have their information, and I would just pick it up, and look at what their specialities were, They don't have in-person conferences now. I still will do any Zoom event because you do get a sense of people through Zoom. And I'll look it up for you, Lori, because the Alzheimer's Association had some directory, and they gave me a whole bunch of list of names of elder care attorneys. So I'll see what that directory is. Yeah, that's how I did it.
Okay, well, that's helpful. I know a lot of times I do a couple of different support groups, and people are so gracious about sharing, I love this person, run from this one, or if it's a service or whatever. But people really rely on that because they're in the trenches going through the process. Quickly, if there was one thing that could be done differently in the process to make you feel more comfortable, what would that be? Is there anything, or did you feel?
Well, poor Lori, don't get me started, but okay. Okay, people, name one other service or thing you would buy that costs $100,000 a year that doesn't provide you with financing options. We don't do college that way. there's the admissions officer and there's the there's financial aid. There's somebody that explains it to you right when you're there. If you buy a car, there's the salesman and there's the finance guy. So you know what it's going to cost. I can't think of anything else where we are expected to put out a great deal of money with no help in understanding how we're going to pay for it. And that's, something I hope would change. But, it's a lot of self-education. And that's why we have you and Lance. Thank you.
Well, and that's a good point. It's kind of like you have to do this self-discovery yourself. Mm-hmm. And that can be really, really difficult to be able to do, because so many people don't even know there's elder law attorneys. They just think that an attorney is an attorney is an attorney. And I'm like, oh no, oh no, they are so different. They're sitting there with their calculator, figuring out what's what, and, working with the financial planners and going through it. I mean, I went through it with my folks, and I found it fascinating and scary. Mm-hmm. And I walked out just so thankful, because I was way in over my head in terms of what was what. I could get the documents and I could organize them in a fashion, but I didn't know about tax ramifications and, gifting. And I mean, the list just goes on and on and on of what we take for granted in everyday life. So thank you so much, Mary. Lance, I'm going to throw it over to you, and we can dive into having you talk with Ramsey and get into the bolts of some of this stuff.
Speaking of an elder law attorney, right? Ramsey, thank you so much for being here with us today. We introduced you as an elder law attorney, so a lot of these questions are going to kind of piggyback off of what, Mary was just speaking about. As we see our boomers getting older, what is the most important elder law issue that you see that people really need to address as they are aging?
Well, I think the key is prepare, prepare, prepare. When you're in the Scouts, the motto is be prepared. You have to be prepared throughout your entire life, not just when you're in the Scouts. Unfortunately, a lot of people defer estate planning. Either they feel it's not appropriate for them, or they feel I'll have plenty of time, or, I'm not going to get disabled. I'm not going to require long-term care. I'd like to know what crystal ball they have. They're basically just in denial. An analogy that I like to use is, let's say you go to the mechanic, and the mechanic says, well, we don't have to worry about your brakes. We don't have to worry about your battery. We don't have to worry about your tires. Well, yeah, you do. Especially, I'm in New England and you're in Minnesota. We have weather situations that require us to do certain things to the vehicle. It's the same thing with us. And there are things that are going to happen in our lives as we grow older. And I didn't start as an elder law attorney. I started as a litigator. I started as a criminal defense lawyer, and I went over to personal injury litigation, and I was in and out of the courts all the time. And then I had a family situation that required me to learn about elder law. And then I said, you know what? Now that I've learned this, I'm going to do this for other people. And that's how I ended up where I am. Yeah. It's a complicated area. There's a lot to know. You have to understand what the Medicaid regulations are. You'll have to also understand what the federal regulations are, because you understand that federal regulations are basically a baseline. And then the states, they can adjust those regulations. They can't make the regulations looser, but they can make them tighter. So, for example, the look back, which in Massachusetts 5 years, and I'm assuming in Minnesota is 5 years, in other states it's not anymore. States have come along and said, we're going to increase it to 7. We're going to increase it to 10. The rules vary from state to state to state. And then the type of trust that, in Massachusetts, there's only one type of trust that allows you to protect assets under the Medicaid regulations. And it's called an income-only trust, because Medicaid requires that all your income be paid to the nursing home. And so the trust has to do that. I had a case not too long ago where a trustee made a mistake and prematurely moved assets out of the trust and distributed them to the ultimate beneficiaries. That's a no-no. And we had to then get that money back and put it back in the trust. And eventually Medicaid accepted that and approved the application. People make mistakes. Unfortunately, the trust, I had written this trust, the trust I had written said, before you take any action, contact me, talk to me, and find out what the ramifications are going to be of taking that action. They figured, we think we know what's going on. They went ahead and did it anyway.
Right.
And then I had to come back and fix it.
And I know you mentioned it, Ramsey, but I just want to also clarify for viewers and listeners who might have gone past them. You're speaking about Medicaid, and you're just speaking about Massachusetts Medicaid, because Medicaid is ran and operated individually by the states, where Medicare is uniform across the country. And a lot of people don't realize that. Medicare is case by case dependent on the state you reside in. Let's talk about some more mistakes, though, since we're on a mistake kick here. What are some of the 3 biggest mistakes that you see people make as they age?
Okay, well, the most obvious one is they don't think ahead to life, to how their lifestyle is going to change. So they don't modify their home. They don't prepare for long-term care or even going into an assisted living facility, and then they find themselves having to make decisions very, very quickly. On the legal side is they feel that they're not going to require any legal documents, and so they ignore that. As I said earlier, they're basically in denial, and they also don't reach out to somebody to find out what they should be looking at. One of the things I recommend to my clients is the first thing you should ask yourself is, what's the family health history? Because there's a possibility, given genetics, that you could have the same medical conditions that somebody else in your family had. And that's not a predictor, but it allows you to make a judgment. And then many times I'll ask you, has anybody in your family required nursing home care? Or have they had issues with their memory, with cognition? And it's amazing how many times you get the yes answer. I've also had the unfortunate situation of people coming to me and saying, it's husband and wife, they come in together. One of them's it's already been diagnosed with dementia. The other one, could you write a new deed so we can transfer the property? I said, the person with dementia is not legally capable of signing. Do you have a power of attorney? We can use the power of attorney and we can do it that way. Oh, no, we never got a power of attorney. I said, now we have to go to court. I mean, it's an unfortunate situation, or sometimes, and then of course guardianships get adult guardianships usually result because of underlying sibling rivalry, result in all kinds of disputes, and sibling rivalry never goes away. It just goes underground.
Right.
And it raises its head later on.
Yeah. And we've seen with our business, sadly and unfortunately, where you have siblings that have great relationships and they've gotten along and there is no sibling rivalry, but as soon as mom or dad start getting ill or sick and they have differing opinions, now all of a sudden that conflict, it gets developed later in life as well. And I love that you're talking about the POA and things. We tell people all the time, don't wait, get your wishes, get all of your, affairs in order while you still are of sound mind and you're able to make these decisions for you, so that down the road, the decisions aren't made for you, and so often, like you said, Ramsey, people, it's going to happen to someone else, it'll never happen to us. And that's usually the people that it does happen to, unfortunately. But at the end of the day, it happens to everybody at some point. It's just a matter of how soon.
We're not bulletproof. Something's going to happen.
Right. Absolutely. Why do you think people ignore age-related disability and end-of-life planning? Is it because of what we just talked about?
It's something you want to think about. I mean, I had an experience with a client. This doesn't have to do with disability. This has to do with death. I had written husband and wife, a will for husband and wife. I'd also written a revocable trust, power of attorney, healthcare proxy, did the whole package. And the husband at the end said, you did a great job. Thank you very much. He says, but it's unfortunate that some of these documents aren't going to benefit me at all, because they only come into play when I die. And that's how people think. They're like, I don't want to think about my death. I don't want to think about my disability. It's kind of like the ostrich putting its head under the sand, that sort of thing. I mean, I think it's unwise. I think people should at least get the information and figure out, what they should be doing given their circumstances and given their goals. What are your goals? Where do you want to go? What do you want to do? I mean, not everybody requires estate asset protection. Some people do. Some people require protection against the federal and the state estate tax. Some people just want a simple garden variety trust to avoid probate, and change the title to the car and the boat and do a new deed, and they're all set. So it really depends on what are somebody's needs and what are their goals. I mean, what are they trying to achieve?
And I would just go back to that client who had mentioned, it's unfortunate some of these things won't benefit or apply to me because I'll be dead. But look at it from the perspective of you're helping your family out, though, so it will benefit them.
I think it's the best gift you can give your family is get your affairs in order.
Absolutely. And same with advanced directives and living wills. We tell people, you don't want to have to make those decisions for your mom or dad or your spouse. That's why you want to have the conversation earlier so that you are in a position of not having to guess or assume what mom or dad may want, because, some families, the dad may want all of the heroic measures possible to sustain life, where the mom is like, just let me go. But imagine if you flip their wishes around because you didn't know what their wishes are, and then you found out later on. I mean, that could be devastating and something you would have to live with. And, it's so simple, it doesn't have to be a serious conversation. You can sit down just casually, just softly enter into that conversation and just see what you can glean from it, so that, you are respecting your parents' wishes, but also taking advantage of, really securing yourself down the road. So if and when that time comes, you are making those decisions, you're making all the right choices for them as well.
It's interesting you mentioned the term heroic measures. Massachusetts will not recognize that term anymore. We have a specific healthcare proxy statute, and we're required to put in there the magic words, do not resuscitate.
Sure.
Because they don't want EMTs or people in the hospital trying to interpret what does heroic measures mean.
Right.
So they say we're going to use that phrase instead. That's specific to Massachusetts. I know New Hampshire is the same way. Other than that, I'm not familiar with any other states.
Thank you for that. Let's talk about raising those subjects and discussing them, such as estate planning, driving, having care in the home, assisted living, and even, down the road, the future outlook for their long-term care. How do you start raising those issues and discussing them without maybe making mom or dad or even a spouse feel like they're losing dignity or control over their independence?
So when it comes to the estate planning, what I'll recommend to people is, have a sit down with your mom and dad, maybe have a cup of coffee and just chit chat, and basically say, we're thinking of doing our estate planning. Can you tell us what you did as a guideline, and who did you use? You'd be amazed. The parents at that point will open up. But if you walk in there and say, "Hey, did you do your estate planning?" They're going to back off. But you just say, we're planning on doing ours, and what did you do and who did you use? They're likely going to tell you, and they'll also tell you if they didn't do an estate plan, which is important information. With regards to the lifestyle issues, specifically with regard to driving, I think the most important thing to do, and it's hard, is to talk to the doctor. Find out who the primary care doctor is and say, listen, I'm noticing mom or dad is problem driving. Can we bring them in? Can you talk to them and let the doctor handle that? Now, some doctors don't want to. Some don't want to handle it. I ran into a personal situation in my family where I contacted the primary care doctor and he said, I'm not going to have that conversation.
Wow.
So I had to handle it myself. It was my dad. He had cancer, and it was just better for him not to drive anymore. So he actually was very good about it. He gave up the keys, and it all worked out.
Good.
Yeah, but I would have preferred if the doctor, his oncologist, said to him, you should give up your keys.
Yeah. Wonderful.
Because remember, I'm the son. He's the dad,
Absolutely.
There's that dynamic.
Absolutely. And it doesn't ever leave that dynamic either.
No, it doesn't.
I want to play Ask the Attorney real quickly before I get to this other question. Could you briefly explain, because I know we get this question from families a lot, And we try to explain it, but then we always say, but we're not attorneys, so we can't give you legal advice. Contact your family law attorney or elder law, or find one if you need one. The death tax, Ramsey. Explain what that means to people.
Okay, well, the death tax is known as the estate tax. And there, depending on the state that you live in, there are two levels of taxes. The federal tax, now the federal tax, I believe the threshold is 5.5 million right now. So it's up there. A lot of people aren't going to be paying the federal estate tax. In Massachusetts, the threshold until just this year had been 1 million. But the thing you have to know about Massachusetts is if you go to $1 over 1 million, the entire 1 million and $1 gets taxed, the entire thing. Whereas on the federal, you have to go above the threshold. And I'm going to have to believe the same in several cases. Now we have a neighboring state, New Hampshire, that doesn't have an estate tax, but it has other taxes to make up for it. Texas doesn't have an estate tax. Florida doesn't have an estate tax. The threshold for the estate tax has gone from 500,000 to 700,000 to 1 million to 1.25 million to 1.5 million to 2 million. In 1 year, I believe Bush's last year in office, there was no estate tax, and then it kicked right back in again. It seemed, from my experience, again, I haven't done this elder law for the entire 40-some years I've been a lawyer, but it seems that every new president, we get a new estate tax law. So, Nixon had an estate tax law, Ford had an estate tax law, Clinton had an estate tax law, and on and on and on. Everybody took their turns at changing the estate tax law. There is estate tax planning that you can do. It's called the credit shelter trust, where husband and wife each have their own separate trusts. They take their assets and they divide them up, and then you take you're able to have each one take a marital deduction, because the way marital deduction works is only one person, if you don't split up your assets, can take the marital deduction, and that's the one who dies second. By splitting up your assets and you put it into this credit shelter trust, you get 2 marital deductions. So if you have an estate that's worth 10, let's say 12 million, and you have $5.5 million threshold, you can double that up to 11 million and pay tax on one. That's how that works.
All right. Good information. My other question is, when families, we talked about some sibling rivalry and things, when you have a husband and wife who did not have children, and families have concern about them, but they're not siblings, they're not children, they're maybe cousins or, second cousins, what have you, what's the best piece of advice for them to get involved? Should they seek a guardianship? And this is assuming that person is able to take on that responsibility. But how do you recommend families in situations like that proceed to the betterment and benefit of the couple that they're concerned about?
The Massachusetts has a specific guardianship statute, adult guardianship statute, and that statute states that the court should appoint the most appropriate person. Now, what most appropriate means is someone who has the wherewithal to take care of this person, has the personality to take care of this person, and also has the time to devote to taking care of this person. So, I know most appropriate person sounds like it could be anybody, but it really isn't, because once a judge delves into this, he's going to say, well, you're not qualified. You're not qualified. So what I advise the clients is say, are you ready to do this? Now, understand you have guardianship and you have conservatorship. Guardianship is care of the person. Guardianship is control of the money. And I like the idea of having two different people in that regard. It's kind of like a check and balance. Because if you have one person who's guardian and conservator, you just really don't know how the money is being used, because there's no oversight.
Lastly, why would someone want to use a qualified estate planning and elder law attorney instead of just these online websites where you can do it for $69.95 and have it done yourself that day?
You can most definitely do it less expensively by going online. But let's understand that I don't know if you've seen these online documents. I actually had a client of mine come in with documents that he printed out of a program called Willmaker. So he had his will, his power of attorney, and he had his medical directive. And on the very bottom, there was a disclaimer. These documents may not work in the state where you live. Consult with a lawyer. What good are they? I mean, they're generic documents. And then to more complicate this thing, my malpractice carrier has instructed me not to review these documents. And if I do look at them and I see them, not to amend them, but start brand new documents. In other words, I might make a mistake in amending this document, and they don't want to be on the hook, so they're going to disclaim coverage if I do that. So the fact of the matter is that you have no protection with online by putting the disclaimer on there. And if the document doesn't work, look, if it works, okay, great. I mean, it can work for let's say a simple will, or maybe for a power of attorney. Again, the states have their own statutes with regards to health. Well, in Massachusetts we call it healthcare proxy. In New Hampshire we call it the power of attorney for medical care. Each state has their own, and they have certain requirements. I don't think the online documents necessarily meet each state's requirements. So yeah, you should be dealing with somebody who understands the rules in your state, who can craft documents, draft documents that comply with those rules, and that person has to stand behind. You know, like I said, I have a malpractice policy. I make a mistake, I'm on the hook for these documents. The online company is not on the hook. So you get what you pay for, basically.
Well, I was going to say you get what you pay for, and people that may not know any better, it could cost them a lot more in the long run when the day comes trying to enforce it, and a judge or whoever rules it null and void, that it's not a true legal document. Now you've just created a whole nother mess for yourself. You know, I think do it right the first time.
And I don't know if these online companies have this income only trust that we talked about before, but in Massachusetts, we have a rash of case law that comes along, and I'd say every 2 to 3 years changes what the status of the law is.
Right.
So it would go back when I first started in this elder law. We were allowed to write something called trigger trusts. Trigger trusts where we could actually allow the person called the grantor who establishes the trust to maintain control. Look back period back then was 2.5 years. Maintain control of the trust and the assets for 2.5 years. After that 2.5 years, that would be the trigger to then convert it to become irrevocable, and they would lose control. Can't do that anymore.
Right.
Now you have, from day one, you have to give up control, has to be totally irrevocable. Third party has to be the trustee. My point is the rules keep changing.
All the time. And the rules today will probably be changed next year too. Yeah. Well, Ramsey, thank you so much for being a part of this and just, sharing your expertise and doing a great job of explaining a lot of these issues that families are facing. I want to go back to Lori now.
Well, thank you. Gosh, I'm just learning so much, and it's pulling me back into the day when I went with my folks, to meet with their attorney. And, Chris had said, get out of the room. I'm going to talk turkey with your folks, and you don't need to hear what they're going to say. And my folks said, no, she knows everything, and we want her in there. And so I got to kind of see the inside workings, which later on I'm going to want to ask more questions about, because I think it's a fascinating process and people need to understand why you guys ask the questions that you do, because some people will feel like they're inappropriate, but they're really critical questions and stuff. But I want to go to Deborah first. And Deborah, my first question to you is, did you, once your husband got diagnosed, did you know right away that you needed to kind of get your affairs in order? I know with your job, you give out that advice, but I also know that what we do personally and what we do professionally sometimes don't mesh. And then we have a personal experience and go, wow, this is a lot more than I thought it was when I'm telling other people to go through this process.
Well, I have to say, ditto to both Ramsey and to Mary. They've pretty much expounded on all of my notes, which is great. So I'm just going to say ditto and confirmation to a lot of what you shared. To answer your question, Laurie, yes, I did right away. When you never know what your spouse is going to say. And one of the advantages is I had, some people are good with finances, some aren't. And right off the bat, my husband said, I want you to take care of the finances. And so having done that, I had already a big picture. But I have to say that because, and every personality of anyone that has dementia, we're all different. And I never knew what his response was going to be. Would he be open to just turning everything over? Power of attorney. And he'd had no qualms. He said yes. And so I got complete everything, durable, and which is your financial here in Alaska, and the advanced care directives for medical. So that was easy. That I called a couple of friends to witness, called a friend who was a notary, and we got it all kicked out of the ballpark very quickly one evening, which was a blessing. I think back on that so many times. But for myself, it's gathering everybody in, making sure that I can get the witnesses, and which I would have no problem. And as you said, Lori, sometimes we talk it, but as a care partner, there, just deciding what you're going to wear for the day. I make that decision the night before, so I don't have to think about it the next morning. It's just one more thing. And I know Mary probably understands that. And so that sometimes hinders you from doing all of the things, because it's like Medicare, and I'm a counselor for Medicare. And people don't even want to think about Medicare. And I understand it's daunting and it's fluid, changes all the time. Advantage in the lower 48, we don't have Advantage up here. So everything is can be more of a mental challenge, and then that affects, okay, I don't want to do this, I'm not going to think about this. And you just have to put one foot in front of the other. I'm not somebody that would jump out of an airplane either, Mary. I don't climb mountains, I don't scale rocks, but I do love the outdoors, and I do have the ability to take the bull by the horns when I have to, and discipline myself. Okay, this has got to get done. Do it. Emotions don't factor in.
It's a tough thing, because typically, especially if it's a spouse, you want them to feel dignified and
exactly.
not stripped, of their personhood or their control. And so often, and I'll just use the example, especially with our older generation, typically the guys were in charge of the finances and doing all the things. And I would hear this all the time in my support groups. Mary kind of references too. And the women, like, I don't even know where the checkbook is. I've never balanced a checkbook. I have no idea what we have in savings. He takes care of all the bills. I don't even know where to look. I don't know where to start. And so, and I think it can be human nature for many people, when they are that out of the know, they just become an ostrich head in the sand and go, yeah, I don't know where to start. And they just get paralyzed. And I think that's, Ramsey had mentioned about, you can go online and you can do these documents. Will they help or not? But I just personally found having a live person I could talk to, I could, read their nonverbals, even sitting across the desk, or being able to shoot an email or make a call. I didn't care if I was being charged for it, because that answer gave me comfort and calm to move forward. And I think people forget how important that is to keep us going in the right direction. One of the other things that I wanted to ask you, because I just think this is interesting, I hear from people all the time, upon diagnosis, people get their diagnosis, they get a prescription, they get another appointment, and as they're walking out the door, they're told, and don't forget, get your affairs in order. And then you kind of go out in the car and you cry for 2 hours, because you're just paralyzed, thinking, the end is coming so soon. And it doesn't make any difference if you have dementia or not. Those are really tough things to hear. Nobody wants to hear they've got a chronic illness, and their life's wishes and dreams are now going to be crushed and have to be modified. And they don't know how long they have to live, because nobody really has an answer for that. What did the doctor tell you guys as you were walking out the door?
Well, I did not have that experience. We did have one neurologist in the process that I did report him to the medical board here in Alaska because he was just, I think he was on something. And Teepa Snow told me, she says, Deb, she says, I think maybe his caseload is too heavy and he might be on something himself to cope with all of the things because just imagine what somebody was like. I mean, he did not have any respect for me as a spouse at all. And I'm living with it, working with Jim all the time. But we went to the psychologist, and I waited for her report. She said to me when she left, well, let me back up just for a second. Because of the work I have been in, and I heard FTD, and I thought, well, I don't know much about this. And this was like 4 or 5 years ago, and maybe 6 years. And I thought, I'm just going to start studying it. And when I did, I went, oh my God, this is Jim. This is my husband. And so I was already prepared inside somewhat. And so when the psychologist wanted to talk to me, she spent 2 hours with me and sent Jim off to get the assessment. And I said, I'm thinking this is what he has. And she says, well, let us do what we do, and then we'll decide. When I left the office, she said, I think you're right, that's what he has. So then we did find at Washington State University a neurologist, which was just perfect. She was the only one who read the scans, who looked at all the material prior to the appointment. And this was through Zoom. And she was very good with Jim. It was, so I think my story is different. Nobody gave me any resources. I'm just that type of person. I was in education for 8 years. I just went and did the research myself and talked to people. And Jim is also a vet. And so his, I sort of went on the periphery of the VA through approvals and referrals. And his provider at this time is a very humble man. He said, Deb, he said, listening to you, I get educated, and you're making me go to the books because I'm not trained in it. Not every doctor is going to say that. And so it was a working relationship. And so I've looked back on the diagnostic journey and said, I've been blessed above what most people experience. And you hear the horror stories and the devastation. And so keeping Jim's dignity has been very important to me. And I've had the one goal of having peace in my home because it's my haven as well as his. And so that's what I focus on as a care partner. As well as taking care of all of the logistical structural things. Anyway, that's more than you asked for, but I'm sorry.
Well, no, I'm glad you had a different experience. One of the reasons I asked that is I think it can, add such panic into the process.
Yes.
And which to me is not a good thing. But I also wanted to just double back on, when you said you had to report a doctor, not everybody's going to be a good fit. And again, just like an attorney, you need to have a good fit and a comfort level with that, because, it could be a misdiagnosis too. And not that you shouldn't go ahead and do your legal papers and get them in order. I think we should all be doing that when we turn 18, actually, and not be so fearful with that. But, one of the questions I wanted to ask you too, because I've heard this happen, and I don't know what your situation is, but a lot of times people go, okay, we're going to get the paperwork in order. We're going to get your paperwork in order. A couple or not, a family or not, it's about you it's not, we don't have to do my paperwork. We just have to do yours. Because again, that there's can be a level of denial sometimes that is still there. Sometimes it can be a cost factor too, where people are just like, we don't have enough to do all of this. But how did you guys look at that? And I see that really even more often when there are remarriages, second marriages or third marriages and stuff.
Well, really, it's not been a problem for me. I'm in the process of doing mine. Mm-hmm. And I also had made sure that because of FTD, their behavior, depending on what variant you have, with Jim, spending money was very easy for him. That's one of the reasons why he said to me, you're going to have to take care of the finances for this to work. Is making sure that you have beneficiaries on all bank accounts, because in the state of Alaska, if there's no other person on the account that has authority to receive those funds, it can be absorbed into the state. And so that I did. So I have our daughter is our second agent and beneficiary, and then a friend of mine will be my second agent, but my daughter will be first. And I've even had some estate lawyers say, well, maybe you should have 6 people because somebody can be in an accident and die, and this can happen, and this can happen. And I'm like, oh my gosh, it's so daunting for what people have to think about nowadays. But no, it's not just about Jim. Even though I have full authority on financial and medical for him, I still include, because with FTD, they can still engage in life. And I don't just run with that and take advantage of the authority that I have. I still include him. So I've never separated what we are as a couple. We're one unit. But I'm here to meet your needs, whatever that means. And if I can keep him at home, I don't want him in a home, another facility. And some people, I live in a very, just like Maine, when I lived in Maine for a short time, and Alaska, we have similar traits of independence. And maintaining a person's independence here in Alaska seems to be priority. So many, I will not. And being in a rural setting like I am, there's a lot of people in this community who just leave me alone. I want to die at home, whatever that means. Okay. And so, did I answer your question, Lori?
Yep, that works.
Okay.
One of the other things I'm interested in is, I know some doctors will say, I'm not going to put this diagnosis that you have in your file yet, in case you want to get long-term insurance, which can be a help, because once chronic illness is listed, that can be tougher to get. Have you heard of that happening? I won't ask you specifically.
No. But I am aware of that, yes. And in my experience, a lot of people don't even know what long-term is. Mm-hmm. I'll say, do you have it on your insurance? Have you been paying into long-term? And they go, what is that? I'd say the majority don't know. Mm-hmm. And it might just depend on your level of income, maybe. I don't know, that people think differently sometimes when they have a big estate. Their thoughts are elsewhere, or they're more exposed to it. And but where I am, we have to sometimes, well, not sometimes, most of the time, present that to the client.
Okay. The other thing was, a lot of times, depending on where someone's at with their illness and what type it is, like with dementia, sometimes people will say, they pull the names off the credit cards, or they don't let them have access to that, or the bank accounts. I mean, I had a personal friend whose mom was living in an assisted living, and she wasn't formally diagnosed originally, but she got on a scammer list, and she was pulling money out. She kept it, and there was a bank inside the senior living community, but they wouldn't do anything. They're like, she's a signer on the account, she can do whatever she wants, and there was no like extra protection to say, hey, are you sure you want to do this, or blah 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 blah, because they're like, that's not our job. And she ended up setting up a separate account, kind of like a prepaid credit card, that she could only access so much money on there. And there's different workarounds, and sometimes people know how to maneuver all of that stuff. Same with with stocks and bonds and things. I had a friend whose father was, he ran a business and he troubleshooted. And so they would shut a door in one area and he'd find another one to open to be able to do what he wanted to do. And so he was still doing trading. They took away the driver's license, and then he's like, I'll call an Uber, and when he couldn't get out, then he started doing QVC, but it was, he wanted to spend his money and do what he wanted to do. And so finding those stop gaps and things can be, super, super interesting, in the process itself. Lance, do you have any questions? Otherwise, I'll open it to kind of a broader session here.
I think we can open it up, and then I got a couple of comments, but not directly for Deborah.
Okay. Sounds good. One thing that we didn't talk about was, and Ramsey, I'm going to go to you with this, is like prepaid burials and, that kind of spend down process. What is wise to spend down? And again, it probably varies from state to state, but can you tell people what a spend down is and why it's important to do it correctly?
Okay, so Medicaid classifies property into countable versus non-countable. And so money that's spent for a particular purpose that Medicaid recognizes, for example, prepaying for a funeral, they'll recognize that takes a countable asset and converts it to a non-countable asset. You're also allowed to have an irrevocable account with a bank for purpose of burial. I believe that's $1,500. That takes a countable asset and converts it to non-countable. And I know Mary earlier talked about Medicaid compliant annuities. That's another situation where you're taking countable assets and you're converting them to non-countable. In this situation, you're creating an income stream, but you have to be careful. The rules on these annuities are very, very, very specific. It has to be immediate. It has to be actuarially sound. The term of the annuity can't be longer than the life expectancy of the person in the nursing home. And there's others. There's a whole shopping list. So if somebody's going to be looking at this Medicaid compliant annuity, make sure the person you're talking to has done these before, because they're not the same as your garden variety annuities that you may buy for investment purposes. Whole different animal, totally different rules and regulations. So the purpose on the spend down, get to your question of a spend down, is if your assets exceed, or the person going into the nursing home's assets exceed the $2,000 plus what the community spouse is allowed to keep. And again, that varies from state to state. You take those two, put them together. Anything above that is considered a countable asset that can be used for the care. So then the idea is to try to spend the money down either for the person's care, or if you pay professionals, like you pay an accountant, a lawyer, a doctor, or if you make improvements to the person's principal residence, that's an exclusion. So there's exclusions that you have to work with, and that's what we as lawyers recommend to the clients. You can do this, you can do that, you can spend this, you can spend that, and we're going to take. And we can take assets that are countable and make them non-countable. And if we still have countables, then we have to use that to pay for the person's care. We have no choice. And that's where these income-only trusts come in, because the income-only trust, if it was established 5 years prior, it shelters the entire amount of that money. And I've actually done that for people who have millions of dollars in assets. Put it in one of these trusts, and person satisfied the look back, home free.
Okay, that was one of my questions I was going to ask you, was does the 5-year come into play even with these changes as well, that they have to be done 5
Yeah.
years prior. Okay.
5 years and a day is the rule I tell clients. And if you don't, and we used to have something called half a loaf. President George W. Bush did away with that, where if you only made it 2.5 years, okay, fine, there'll be some sort of penalty, but we'll approve you. Now you have to actually make the 5 years. If you don't, then the entire amount of money is available.
And every state is different again on this. I just want to make sure that
yes. I'm speaking specifically to Massachusetts.
Yep. And Lance, you had a question, so go ahead.
My biggest takeaway, and there's so many good takeaways from this discussion today, is, and I think it was Deborah who mentioned it. Maybe it wasn't Deborah, but somebody recently mentioned about, everybody should get their affairs in order starting at the age of 18. And maybe that was Lori, actually, now that I'm thinking back. I actually was in a hospice course in college, and one of our assignments was we had to purchase 5 wishes. And 5 wishes is recognized, I think, in all of the states except for 1 or 2. And it's not replacing an elder law attorney or an attorney, but it is a legally recognized document, not requiring any sort of notary. What it does is it just lets you, designate who you want to be your POA or your advocate, but it goes through all of your care and all the aspects of your care of how you want to be treated in the event that you can't advocate or communicate for yourself. And it was just a very eye-opening thing. And I did that as a very, very young college student, not understanding at the time, well, why are we filling this out? I was one of those, I'm young, it's never going to happen to me types. But it really gave me a whole new perspective by going through that document. It's not very intensive to fill out, but it does make you really stop and think and, recognize in the event you were to not be able to speak or act on your behalf, what do you want to have happen and who do you want to be advocating for you? So I always recommend to people, get your affairs in order today, not tomorrow, because tomorrow's not promised. And so you want to make sure all of your wishes are respected. And another tip, if you're going to designate somebody as your advocate or your POA, it's a good idea to probably talk to them first about it to make sure they're okay with that.
Exactly.
And then just the other thing is to, when you have questions or you want to have conversations with your family or loved ones, don't be afraid to have those conversations. They might be afraid to have the conversation with you, and you find out both of you wanted to talk about it, and then you can have a really good understanding and a conversation to help both of you, in the future and down the road.
Yeah, that's wonderful. I wanted to ask Mary and Deborah this question and then have Ramsey follow up with this. In your planning, and I'm going to go to Mary first, did the conversation ever come up when you were figuring out all the legal paperwork? What happens if I go first?
Mm-hmm. Yeah. And good attorneys will always ask you that, so, and it's not, not to get hung up on it. You do the best you can, with the knowledge that you have, and remind yourselves that wills can be updated. But
Right.
yeah, our wills were written with that in mind. And are slightly different. And as a matter of fact, I need to do some updating of mine because of asset transfers that we did to me from him to lower his assets, and then what he wanted, portions of that money to go to. So.
Okay, thank you. Deborah, how about you? Was that something you guys talked about with your attorney?
I already thought of that, and sometimes I think in the beginning I thought, okay, he's the one with dementia, so we're it's going to be declined from here on. And then one day I thought to myself, there's no guarantee that he's going first.
Mm-hmm.
There's and so I had to backtrack on that one and start thinking in that way. And thankfully, with only having one daughter, it makes it pretty simple. And she can fully be trusted with any decision she takes to heart. That's a plus. That's an advantage, and that I have in this situation. That I know that if I became incapacitated, she would not make the wrong decision.
Okay.
And But I wanted to say one thing with what Lance just mentioned. An estate lawyer once said to a group of us that if you have a banking account, if you're 17 and you have a bank account, if you're 18, of course, when you're 17, the parents would probably fall in play there. But she says, if you have a bank account, then you need to get your affairs in order, everything. Because if you're old enough to do that, then anything can happen, and you're an adult now, so to speak.
Yeah, and adding that beneficiary onto the account.
Yes.
Is something that, I have found that most banks don't ask you for.
They don't ask. And that's the other thing, Lori, you said so many times, people don't know the questions to ask. Mm-hmm. And so that as my position here with ADRC, I try to project some of that stuff and a friendly manner, not with a pointed finger saying this is what you need to do, but you need to consider, because there's so much out there. The surprises of the unknown are amazing, especially when people do pass away. And that really was brought to my attention dramatically when a gentleman here in the community who had already had one wife expire, and then his second wife also died. And he was a man who had everything in order. And he said, I could not believe it when something had changed in our state and something else needed to be addressed. And he had no idea and nobody told him. And thankfully it wasn't major, but there are those unknown factors. And that was one of the things that I wanted to bring out in this discussion, that even in my own personal experience and in others, some people get the power of attorney at the hospital. Well, that doesn't cover everything. It only covers for that hospital, at least here in Alaska. And so I tell people you need to go with the statute-supported, court-supported power of attorney for the state of Alaska and see that all of that. And then you have to go beyond that once the person passes away anyway.
Yeah, because a lot of times Social Security or the VA, they want their own, POAs and all of that kind of stuff.
You have to ask about that.
Yeah.
Lori,
Ramsey, Oh, go ahead, Mary.
Excuse me. Another legality that I haven't followed up on personally because I just found out about it, but it's called a digital asset authorization. And what as my understanding, it's like I put in my will, it would, if I would die, it allows the trusted person I name access to passwords and things on my computer that are stored electronically. This is, I guess, I'm assuming kind of new in Minnesota, but because I don't have children, and of course I'm assuming that I will outlast Roger. But the point is that it's another kind of legality that along with like what Deborah's saying about POAs on bank accounts is who has access to your digital profile. And so just wanted to mention, I'm sure Ramsey can do a better job of explaining what it is. But
well, if I could just jump in for a moment, I know on Meta, so Facebook, Instagram, you can go into the settings and there is a place for you to list I don't know if they call it an error or however it's phrased, where you can designate somebody in the event that you do pass, that they would have access to be able to take over your social media accounts.
If I could put a plug in, I came across a book called I'm Dead, Now What? And I've got the 5 wishes here in the office, and I also have an end of life book that's very, I pass out to people and have given to the hospice group. I'm Dead, Now What? Covers just about everything, or it provokes another thought that you would want to record. And they tell you not to write down your passwords and everything like that and usernames. But I do have that in a secure location that my daughter will be able to go through everything that I have in an account with and do what's necessary. Some things, especially those that I pay a membership to, she'd want to cancel those.
Yeah. Well, and it's interesting with those passwords. They don't want you to write them down. They want you to put them on the online thing. And it's like online's getting hacked every other day with stuff. So it's kind of like, okay, do I trust myself and my house? And
yeah, is your hippocampus working?
yeah, all of that kind of stuff. Ramsey, I'm going to go to you, and I first want to ask my follow-up question that I asked Mary and Deborah about, preparing, families for the what ifs, because they get so, I think, focused on this person is ill and we're going to live forever, and not having like a backup plan. I would imagine that's part of the process that you go through when you meet with families.
I always recommend that people choose several successors. So if we're doing a will and we have a personal representative, and if we're dealing with husband and wife, they will name one another's primary, but then we'll have a successor, and then we'll have a successor after that in case that person doesn't want to do the job or can't do the job, or that person prematurely passed away. And we have several. I am not a fan of co-trustees, co-personal representatives, co-attorneys, in fact, because the law in Massachusetts is they have to act unanimously. And if they can't act unanimously, then you have gridlock. What good is that? So I always like to have just one person. One person is going to make all the decisions. And we have several successors, and it may sound like overkill, but you just don't know what's going to happen. So I ask my clients, who do you trust the most? Who do you want this person to be? I let the client choose that. So that's not my job to choose. It's just my job to make sure that we don't end up with a situation where the ship is on the ocean and it's ready to sink and there's no captain. What are we going to do? We're going to have to run to court. That's even more expensive to do all of that. And I've run into that. I've run into situations where somebody years ago, they created what's known as a realty trust for the purpose of owning real estate. And they had named themselves as trustee, and then they had resigned, and they appointed somebody else, and that somebody else took over. That somebody else passed away, and then my client comes to me and says, "Oh, can you help me with the closing?" And I look up the deed, and I said, "Well, who's going to sign this deed?" Oh, I thought it was all set. I said, no, we have to now go to court and present the document to the court, and then we have to publish in the newspaper, and we have to do all this stuff. I said, so there's nothing. Unfortunately, an additional successor was never appointed, and really was on the first successor trustee to go back to whoever the lawyer was and say, hey, listen, I need somebody to back me up in case something happens to me. It didn't happen. With regard to bank accounts, there's something called transfer on death, pay on death. I think that's a fantastic, inexpensive way to handle a bank account. Again, I'm not a fan of having joint bank accounts. I've seen this happen where you have mom and son, or mom and daughter on a joint bank account, and a son or daughter declares bankruptcy, and the next thing you know, there's creditors swooping in saying, this is part of the bankrupt estate, or there's a divorce, or this is part of the marital estate. You don't want that. So do a transfer on death, do a pay on death, and keep it out of somebody's estate, until that person passes away.
Could I ask a question to that, Ramsey? Like, I'm a beneficiary on my granddaughter's account, but we put her mother on, and she has no signature authority. Would that work, or you still prefer the transfer upon death?
You're saying the mother ose the account?
The granddaughter owns the account. I'm a co-signer on the account, but her mother, if something were to happen, then Kristen would be the beneficiary to the whole account.
So are you all on the account jointly?
It's not joint.
So the caption when you get the statement doesn't have 3 names on there.
I don't think so.
So then she's not a joint owner. She's not a joint owner.
Right. Because my daughter doesn't have any, she has no authority to do anything with the money, only if the daughter should pass away, be in an accident or something. I just didn't know that a beneficiary here with our bank it's different than being joint.
Okay. Well, beneficiary usually comes into play after the primary person on a bank account is no longer with us, That's
Right.
usually how
Okay.
that works.
So is that the same thing as transfer upon death?
Well, I know in New England that we have, it's not just Massachusetts, we have this TOD, transfer on death, pay on death. And you're right, the banks don't tell you about it. But if you ask them about it, oh yeah, we have one of those. And
Well, I will.
It's a
do
back
that.
office function. All they have to do is put TOD or POD next to your name. That's it. That's all they have to do.
Okay.
The back office function.
Now, one of the things I'm just going to ask on this, because I know there are people out there with companies. I've heard that you can't do that with a business account, though.
No,
Yeah,
you
I
can't.
think-
No, it's your own personal account. And there are some states that let you do what are called transfer on death deeds. Massachusetts is not one of them. I don't think any of the New England states are one of them. What we have to do here in Massachusetts, first of all, with regard to real estate throughout the country, it always takes a new deed to pass an interest in real estate. And in Massachusetts, what you would do is you would have the person who's the grantor, who's granting the property, retain a life estate, and their estate would extinguish when they passed away. And then they would then have another person named as the remainder tenant, which means they own what's left after the life estate, which is basically the entire piece of property because the life estate is extinguished. And that's how we deal with it in New England, is with that type of deed. And it avoids probate and it's safe.
Yeah, in Minnesota, there is you can do a transfer of the deed upon death. I've had a few friends that have done that. And but again, you need to know the legalities of everybody involved, and it gets complicated. In with the life estate, I have I used to sell real estate for 25 years, and I would have people, they do the life estate. Well, then the kids would say, well, we're going to sell the house now. And then all of a sudden they have all these tax ramifications, and they're like, well, what do you mean we have all these? It's not our house. And it's like, well, yeah, it is.
Yeah, it is. It is.
And so they don't really understand all of that stuff fully, or, someone's getting divorced and now, the spouse wants part of this because they look at it as part of their assets. I mean, it can get complicated really, really quickly. Go ahead.
The most complicated situation is where we create this income only trust. There's a principal residence, and we move that into the trust. We satisfy the 5-year look back period, and then the trustee decides, along with the beneficiaries, we're going to sell this house, and we'll park the money back into the trust. Now that's going to trigger a capital gains tax because you're selling this thing. However, the person that's in the nursing home is going to be entitled to a portion of that money, and that money will be paid over to the nursing home. And then the other money gets divvied up, and that person in the nursing home is going to get a bill to pay a capital gains tax. Because most of the clients I deal with, they bought property when it was $50,000, $70,000, $100,000 maximum, and now we're selling it for mid 6 figures or higher. There's going to be a capital gains tax.
Yeah. I know with my folks, they did, more than the 5-year look back, and my mom ended up on medical assistance, and they still put a lien on their home. And what cracked me up was they estimated she was going to live to 108. And I'm
really?
like, what? I talked with the county, and they're like, oh, some of them come back even higher than that. And it washed off. But I was told they put a lien on it because today it meets the law, but maybe the law will change in the future. And they wanted to make sure they could still get their hands on things if the law changed and if it went retro. I mean, it was all the what ifs, because it is really costly, with all of these things. Now, Mary had brought up the digital assets, and I saw your head shaking. And I know like 2 years ago when I was talking with an attorney here, I heard that, and I'm like, is there a form? And I was told, no, there wasn't a form. And it's like, why don't they just add that one line onto the POA that says click?
That's what we do. We put it in the power of attorney. But the way I write the power of attorney, I will say, I hereby appoint so-and-so to handle all my digital assets. And then we have a document that no one will get their hands on that has the passwords in there. It's a separate document.
Yep.
See attached document for additional information, and we keep that document separate.
Okay.
So if some member of the family gets their hands on it, inappropriately, we don't want them suddenly going in. I mean, digital assets can also mean bank accounts, brokerage accounts. I mean, it means everything. Everything's online today. It's all out there.
Yeah, that's very, very true. I wanted to ask about family dynamics, Ramsey. I'm sure you see this. I mean, we all have it within our own families, but what do you do when they're, it's like the hawks are just coming in, trying to scoop things up. I know in my own family, we had an issue with that. And the attorney, my dad, for example, he ended up back in the hospital. We were in the process of doing the documents, and the attorney said, I will meet you in the emergency room, because we were supposed to go there that day, and we will get this signed. And I had a brother who, was trying to manipulate things, and she just put him right in his place. But not all attorneys, I think, will do that. How do you handle those family dynamics when you know that some people might be trying to manipulate what's going on? We had, I'll give one other example. We had where the power of attorneys were done, and then they had them sign new powers of attorney and didn't tell anybody. And then it leaked out, and then we had to redo them again and stuff. I mean, there's so many goofy things that can happen within families.
No, there are, and every family has got some kind of dysfunction, some more so than others. But I mean, I have dealt in my community. I've had as clients people who are considered the pillars of the community. Mm-hmm. They had internal family problems. They all do, and it's a matter of degree. That's really what it is. So in any event, a lot of the situation I see oftentimes is a son or a daughter will come in with mom or dad, or mom and dad. They'll bring them in. And and of course, my clients are mom and dad, not the son or the daughter. Mm-hmm. And as I'm asking mom or dad the question, they're never answering, because the son or daughter just jumps right in and answers. And so what I do at that point is I pull out $5 out of my pocket. I give it to the son or daughter. I tell them, go up the street, go get a coffee, get a donut, bring your cell phone with you. And they're like, what? I said, I need to talk to the people who are going to be my clients. I said, so you need to leave. You need to go get yourself a coffee and a donut. I'm going to pay for it. And then I will call you when you can come back. And it's amazing the stuff that I suddenly hear from mom and dad, because I will then ask, what's going on in the family? What are the relationships? And they'll tell me everything. And then I'll call the other one back, and the other one will be absolutely surprised, because I'll say, can I tell your son or daughter what you told me? Oh, yeah, sure. And they're like, that's not what we talked about. We didn't talk about that. I'm like, this is what I was told, and this is what I'm going to do. And you're right. You do have the competing powers of attorney, the competing health documents where they come to me. We'll get one set, and next thing I know, oh, mom, they took mom to a different lawyer and she got a different one. I'm like, I end up calling the lawyer. I said, are you aware there's another one? Well, the new one supersedes the old one. I said, okay, we'll do another one. We'll play this game. It's ridiculous.
Yep.
Yeah. One thing, Lori, I wanted to mention kind of before it gets to the attorney, at least in Minnesota, there are several really good social workers that in like Family Means and Wilder that will work with families just to understand Alzheimer's and the progression of the disease and issues to be aware of. In other words, trying to get the siblings on the same page before somebody is really ill, or you're under pressure to make a major decision. And so I've suggested that to friends of mine that have asked me, because it provides, or even when a concerned son or daughter wants to talk to their parents. I think Ramsey had a beautiful way of addressing that, but there are people out there that can, I want to say, mediate or aid the discussion or frame the discussion so that the person who has the most concerns doesn't have to be like running the meeting and participating in the meeting.
Yeah. And there are formal mediations that sometimes families have to go through, but it can be really interesting, and it can, rip families apart in terms of the understanding of things. like I said, I was able to be in the meeting with my folks for their meeting with the elder lawyer. And, and again, it was a personal friend of mine. She's like the top elder law attorney in Minnesota. And she's like, no, Laura, you can't be in here. No, 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 no. I need to talk to him in private. My folks were like, we're not going to do it unless she's in there. She knows everything. We trust her. And so Chris is like, okay, but if there's a point, I'm going to just kick you out. I mean, she was really, really honest with me, but I was shocked at the questions. And, like, how stable our marriages? Is anyone an addict, from sex to drugs to whatever? How financially stable are they? All of those things. And people don't think, when they walk into the attorney, they don't think they're going to be asked those questions.
Right.
They don't understand how they apply and how important they are. And in this day and age of divorces and all of that kind of stuff, I mean, you think of how many people are swayed by their spouse. Like, well, they would never do that. Why are they saying that now? And it's like, well, because they're being fed that from somebody else. And that's the dynamic of their relationship that now has an effect on this. And so I think it's just so critically important to, have somebody that digs deep and really understands. And I think many times families don't want to share that information because they're embarrassed. But like you said, Ramsey, every family's got their twists and turns.
They
It
do.
might look
They do.
pretty on the
Yeah.
outside, but on the inside, you open up that door and everybody's got their own Pandora's box for the most part. Or even if it's not there in the beginning, it can happen. All of a sudden, money becomes really important and it was never discussed, but now it's on the table. And now you're seeing and hearing and, actions of people you never would have thought would act this way. And so, it's very, very interesting. I did want to ask you another question that I think is really important. We've talked about the look back period. What happens, somebody here, and I can't remember if it was you, Ramsey, or someone else said, money was dispersed, the 5-year look back, they had to give it back. What happens when they don't have it? They've spent it,
That's a problem because the terms of the income only trust basically state that the assets will remain in the trust until the grantor passes away.
Mm-hmm.
It's very, very clear. What they have done is they have distributed the assets outside of the trust while the grantor is still alive. That's a violation of the trust that makes these assets under the Medicaid regulation countable. And if they don't have the assets, they have a problem on their hands because now they're going to have to pay for mom or dad's care. But in the case I had, they were able to take the value, that money value, put it back in the trust, and it's an income only trust, so that money is going to be earning income, and the rates in the bank are still relatively low. But whatever that is, that's going to go to help defray a cost of in this case the mom's care, and then Medicare will kick in. But we were able to fix it. You're right. If they can't fix it, it's a problem.
Yeah.
Can they be legally liable and maybe if they don't have the funds?
Well, yeah, because as the trustee has a fiduciary obligations to the beneficiary of the trust, and the trustee violated that fiduciary duty by making that distribution. Now, this is all family, so hopefully they wouldn't sue one another, but it's a problem.
You never know.
Thankfully, it was fixed.
The other thing I want to ask is, because I hear this question all the time, is as a spouse, how do I protect my assets? So, will everything get drained? Are they gonna take our house? What am I gonna do if they pass? What am I gonna have left? How do you answer that?
Well, the rule in Massachusetts, and I think the rule through a good part of the country, is that a spouse is responsible for his or her spouse's necessaries. Necessaries are roof over the head, food, clothing, medical care, i.e. nursing home care. So the answer to your question is you can't protect yourself unless you create an instrument like this income only trust where you park the money outside your reach. The grantors, husband, wife, they are only grantors. They can't be trustee. They can't be beneficiary. They totally give up control. And that's what allows the asset protection rule to kick in. Now, with regards to charge card debt, it would be immediate, the protection, but with regards to I was going to call it Mass Health, Medicaid, there's this 5-year look back. So you have to make sure you create this 5 years and a day before, and please don't sell the assets.
Now, you just brought up charge cards, because I hear that a lot. When someone passes, is the estate liable for that, or does that just go away? Because I've heard.
Well, the charge card company is going to try to collect, but what I recommend to my clients is say, listen, we're filing a probate. We're going to get a docket number, give them the name of the court, and give them the docket number, and let's see if they file their claim. Massachusetts, they have a limited period of time to file their claim. If they don't file their claim within that limited statute of limitations, then the claim goes away. Okay. And so that's what and there was one situation, this is kind of comical. There was the woman that had passed away. She was in a book club, and they were sending her stuff every month, and they were notified that she had passed away. And they said, well, we sent X number of books and we never got paid, and we want to get paid. And I wrote to them and I said, listen, here's the docket number, here's the court, file your claim. They didn't file their claim. They kept writing. So finally, her husband came to me and said, listen, what can we do? I said, I'll tell you what. In those days, this is how far back I had a Polaroid camera. I went to the cemetery. I took a picture of the headstone, put it in a letter. I sent it to him. I said, please send all your future correspondence to this address. Never heard from them again. They just wouldn't give up. Most of them do. Most of them, they'll talk with a lawyer and say, listen, it's not worth it.
Oh, they'll write it off as a loss, right?
Yeah, I mean, you were talking a $500 bill, and you're going to pay a lawyer $1,000 to file the claim. It makes no sense.
Right.
Yeah.
Another legal issue that I thought of, and I preface this by saying, my husband was always somebody that did everything himself. And so he was the kind that was, trying to convince me we could do our wills online. And I was like, no, we cannot do that. But I got into an attorney because from a previous marriage, he had an adult disabled son, and we needed to set up a special needs trust, and you need a lawyer for that. And so again, and I'm still working on it. It's almost done. But, again, I think we as caregivers, it's not uncommon that we're not just taking care of, our spouse, but there can be other family members that are in this category. So another reason you need an attorney, and that's what we did. So
you should ask your lawyer to give you a list of the types of payments that you can make out of special needs trust, because there are limitations on what you can do.
Yeah, we've got that. A good point, but yeah, it's listed out in the trust what it can be used for, the purpose, but yeah.
One last question I have for Ramsey, and that is, what do you say to people that go, we just don't have enough? We don't need all this stuff,
So I tell them that the term estate means property. Do you have property? If you have property, you have an estate. Some people have a small estate. Some people have a moderate estate. Some people have a very, very large estate. Everybody has some sort of estate. The issue I focus on is, do you have property that has a title or a deed or that sort of thing to it? If you do, and of course, bank accounts, brokerage accounts, life insurance policies, retirement accounts, they're all considered title property. Then you really need to do something. If we're just talking about somebody who's got some furnishings and some clothes, and they don't want to do an estate plan, I'm like, okay, no worries. You really don't have a whole lot. But title property, I do worry about. A boat, an airplane, I worry about that stuff. You should have a plan in place. We had a lawyer in this area here who he was interested in buying a Learjet, and he did. He set up a corporation to buy the jet. Then he had a trust be the beneficiary of the corporation, and he ended up in a situation where he crashed a plane and he died. And then nobody knew who really the owner of this plane should be. He had done this in order because he didn't want anyone to know he owned the plane. But he had so many layers in there that people couldn't figure out, where this plane should be going.
Wow. Yeah, it gets complicated,
It
all
is.
of this stuff, and we all have our ways of thinking, well, we'll wiggle around it, but
Mhm.
you really do need an attorney,
Yeah.
I think, to process
But
this.
at least to find out, get information, find, so you can make an informed decision.
Yep. And like Mary said, most attorneys will do, a free consultation so you can see what's what. I think so often people, especially those that think they don't have enough, they don't understand how much things cost
Right.
and how that's going to delete things and why it's so critically important to be able to protect things and again to have a conversation of even your wants and your needs. Everybody wants to control their life, but when it comes to end of life, they're like, well, no, I'm so uncomfortable with that conversation. I'll give up control over that portion, and the kids can deal with it, or somebody can deal with it, but they don't realize the amount of stress.
But the comment I hear a lot, especially from husbands, is, "Oh, my wife will get everything." I said,
Mhm.
"Without a will, she's not going to get everything. She'll
Right.
she'll get a lion's share, but she won't get everything."
Mhm.
Like, what? I said, "She's not going to. There's state law. It's called rules of intestacy, and she's not going to get everything."
Yep. Well, this has been a fabulous conversation. Lance, do you
Yeah.
have any last questions you want to direct to people, and then we'll open
Not
it
so
up?
much. Not so much a question. Just thanking everybody for their time today. This was really educational. I think it'll be very beneficial and helpful to a lot of viewers and listeners. I would just about the taking care of legal documents on your own versus investing in an attorney. A good friend of mine is a lawyer, and he always is fond of saying people that want to do their own legal work. He said, you can do it, doesn't mean you should do it. Just like you don't have to have a dentist license to practice dentistry, but would you want to go to a licensed dentist or somebody that's just working on the side? You want to go and have that trust and that support because as Ramsey said, the laws are constantly changing. They're going to know the ins and the outs, and these quick one-stop shops are just, it's very generic, and you want to protect yourself as much as possible. So thank you all again for joining us today.
Thank you.
I just thought of one last question for Ramsey. How often, because a lot of times I think people go, I got the documents done, I'm going to put them in the shelf, in the safe. I don't have to worry about them anymore. But don't they really need to be reviewed on a regular basis?
As circumstances in the family change, you should review. I mean, our rule of thumb is 5 to 10 years you should do a review. But if in the interim there's been you have a new child, a new grandchild, or somebody passes away, or you end up with a windfall, you win a lottery, any change in your life, you should go back and look at the plan and review it. It's actually short money just to find out, is this plan still doing what I intended to do? And if it is, fine. If it isn't, well, then we can talk about how we're going to change it and in order to make sure you reach your goals.
Yeah. Well, and like a divorce, or a lot of times people have a house in a trust and they'll move and they'll sell it. That'll pop up and it'll get transferred and signed all right. But then they buy a new one and the new one doesn't always get into the trust.
What people need to understand is that beneficiary designations take precedence over the will. So I'll give you an example of something that actually happened. A local banker called me and said they had a customer and she was in tears. And would I talk to her? I said, sure. I got on the phone with her and she said she was the second wife. Husband, who was a doctor, had divorced his first wife. And by operation of law, the first wife no longer had any right to inherit. But he had her as primary beneficiary on his life insurance. And so after he had married his second wife and then he passed away, he had never changed that beneficiary designation. And the second wife was counting on that money to pay for his funeral. And the first wife said, hey, it's my money. And she was right. It's our money. He never changed the beneficiary. And it superseded in the will. He had disinherited his first wife, but the beneficiary designation superseded that language.
Okay, good. Deborah, you had your hand raised?
I do. For Ramsey, here, when I had a lawyer come and talk about all of this stuff, he mentioned that there's a vault at our courthouse in the nearest municipality, that some of these legal papers, especially ones that people who need to know, anyway, the authorities can go to the court and say, does this person have their things on file in the vault? Are you familiar with that?
No, in Massachusetts, no documents get filed with the court unless the statute specifies. So, for example, with regard to a will, the statute specifies that if somebody passes away and they have a will and the will contains titled property, you have to file the will within 30 days of death. If there isn't, you don't have to file it. And we never file wills because wills, as you know, people will change them. They'll do codicils or amendments, and trusts don't have to be filed at all. And so I asked my client to keep it in a safe place in their home somewhere. We don't file anything with the government unless the statute requires us to. And with regard to wills, we're supposed to file within 30 days. And that's with the court, and that's a public record, and that's why I don't like to file anything, because it's available to the public. Any person can walk in and say, I want to see the file on so and so. They have to show it to them. It's public record.
Wow.
What happens if they don't notify the court that there's a will in 30 days? Is that because of otherwise they got to go through probate?
No, well, the thing is, like I said, if there's titled property, they want you to file a will because there has to be a probate. And if you miss the 30 days, there's no penalty as long as you file. I think they put the 30 days there in place to kind of say, hey, people, you need to do this, and let's get this done sooner rather than later. I've had people come to me. I had somebody come to me 2 years after somebody died. Oh, we have to do a probate. We did it. We filed for probate.
Okay.
The court didn't penalize them.
Sounds good. Sounds good. Mary, any last comments that you have? Any last thoughts?
It's always an interesting journey. And the thing I would just say to all the 24/7 caregivers, think of it this way. You're saving your family $100,000 a year. So value yourself. And, when you need to spend a little extra on whatever replenishes you, be sure to do that.
Okay, thanks. Deborah, how about you? Any last minute thoughts?
Wow. I would just, this isn't a legal thing. I would just say to anyone out there who does have a loved one that they're caring for, to search out information from either those who have experienced it on the legal side of things, but also just educate yourself on what you're dealing with. You cannot go wrong, but check out your source. And because there are, as you know, there's a lot of people out there. That's why, Lori, I pass your name on and I pass Teepa's name on, because you're two trusted sources that I know if you don't have the answer, you're going to find the answer and pass that on to someone. But educating yourself definitely relieves a lot of stress. Talk to lawyers, do whatever you have to do to make your life, because you've got enough to be burdened with and to deal with caring for your loved one. There's some things you just have to let roll off.
Well,
and pass on.
And doing this prior to a crisis hitting, a chronic illness.
There you go. Yeah.
That's the time to do it, because your head won't be as muddled.
Right.
You won't feel as overwhelmed, and you'll be able to process things a little bit easier. We have to somehow get rid of the stigma of, if I do a will, I'm going to die. I mean, that seems to be the thing, and it's like, well, what about the other side? If I have it in place, I'm not going to need it. Let's push that one forward and live better.
I'm just going to say too, after someone passes away, as we all know, that's not when you make major decisions, because the cortisol level, everything is just crazy, and people are not thinking straight. They think they are. But then afterthought and hindsight, I shouldn't have said that or done that.
Yeah. Well, and that's a good point too, because a lot of people still think the power of attorney is still in effect after someone dies, and it is not at all.
It is not.
Ramsey, anything that we didn't cover that you think that that people really need to know? I'm sure we could talk to you for a week on this, but
well, Medicaid actually allows something called a caregiver agreement. It's an agreement that's written out the terms have to be reasonable and the terms have to be negotiated, and obviously both parties have to be acting voluntarily. And in that caregiver agreement, the caregiver who's providing care to the elder parent who's living at home will get paid for his or her services. But again, it has to be a reasonable amount, and then the terms have to be negotiated, and then the caregiver has to declare that money on his or her tax return and pay whatever tax, because it's considered actual income. And that's one way of taking countable assets and converting them into non-countable. I hadn't thought about that before, but I heard Mary mention caregiver. I was like, yeah, there's this caregiver agreement that we didn't talk about.
Oh yeah, that's a really important one. Is there a ballpark like dollar an hour amount on something like that?
Well, I used to quote $20 an hour, but not now that people at McDonald's are being paid $20 an hour, we're going to have to raise that to something else.
Okay, wonderful. Well, I can't thank you enough. I've learned something. I appreciate everybody sharing their stories and their expertise. I think this is going to help so many people. Lance, you want to go ahead and wrap up?
All right. Well, again, I just want to thank everyone. My parting sentiment is it's never too early, but it could be too late for planning your affairs and getting them in order. So again, Ramsey, Deborah, and Mary, and of course, Lori, thank you guys so much for another great discussion on conscious caregiving with L&L.
Well, I like to use Ben Franklin's quote, education pays the best interest. I think this was very informative.
Absolutely.
Yeah.
Yep.
Thank you very much for the opportunity.
Our pleasure, guys. Thank you. Have a great day.
Thank you.
Thank you for joining us again here at Conscious Caregiving with L&L, where we're tackling the tough conversations. We look forward to seeing you again here next month.